Hey, everybody. I am going to talk to you a little bit today about a fascinating federal law that exists that actually allows your family to take over your mortgage after you die without having to refinance or without having to get a new loan. It's called the Garn-St Germain Act. And basically, this is a law that was enacted in the 80s. And what it did is it preempted state law. And there were some states with laws that basically prevented due on sale provisions in mortgage contracts from being enforced. And so a seller could basically transfer their great interest rate, their great loan terms to a potential buyer because state law prohibited the due on transfer or due on sale clauses in these mortgage contracts from being enforced. And so federal law was created, and what it did in part is it preempted state law. So federal law is superior to state law in most things. And so the federal law said, well, that's not a thing. Due on sale clauses are effective. And there are only a handful of exceptions that were created in that law. And the exceptions are where probate attorneys live and breathe, or estate planning attorneys live and breathe, is because there's some exceptions in there that are very valuable to people who are doing planning or after people die, that make the necessity of going through the process of trying to get an independent loan and trying to refinance and deal with assuming mortgages or any of that stuff, it makes that process a lot easier or unnecessary. So what happens is, let's say you buy a house, a residential home, right? And as part of that purchase, you get financing, right? You get a loan, and you secure that loan with the property that you're purchasing. So it's just a typical mortgage. And what happens, though, is some people die before they've paid that mortgage off, and then their family inherits this property, either by will or by the default laws that are in place if you don't have a will. And in either case, right, you'll have a family member who has a house, but they'll also have a mortgage in most cases. And it might be a mortgage that they can or can't afford, right? They might be in a position when they inherit this real estate, they might not be credit worthy, right? They might have their own mortgages and other things that prevent them from being credit worthy to carry a second mortgage. They might be able to handle the cost of a second mortgage, right? They might be able to leave their rental arrangement and go and move in and substitute their rent payments for their mortgage payments. But they might have bad credit, right? They might not know for sure whether long term they can afford to maintain the home or keep the home or whatever it is. So the Garn-St Germain Act, one of the exceptions is that if you get a piece of property as a result of someone else dying, right? They've died and you've inherited their property, well, then you don't have to go get a new loan. You can just keep paying the dead person's loan. And that deceased person, they still have that loan in their name. It still has to be satisfied, or else the mortgage company will come and foreclose and they'll take the property if you default. But you don't have to get a new loan. That can present some problems because if the loan's not in your name, the mortgage company might not talk to you. So usually what we would do is we'd open an estate for a person, and then we would get in touch with the mortgage company and advise them, show them proof of paperwork of who's been appointed to be in charge of this estate. And then we would give them directions to communicate with whoever the new owner of the home would be. And then from there on, usually those things get sorted out, and it's not usually a problem communicating. But, if you're talking to bankers about what's required, or you're talking to mortgage loan officers about what's required, you might be misled. And if you're misled, then you might go and get another loan or refinance or something like that. Well, with interest rates that have going up periodically, you might inherit a house that has a very low interest rate. You might want to keep that low interest rate. Now, if you make payments on that, it might not positively affect your credit because the loan's not in your name, it's in a deceased person's name, right? But at the same token, if you find out you can't afford this for some reason and you let it get foreclosed on, it doesn't negatively affect your credit either because the loan's not in your name. You're not the borrower on this contract. Even though you might own the real estate that can be taken away if you don't pay the payments, right? The real estate still secures the loan. You're not legally bound to pay it. Yeah, they can take the real estate, but they can't make you pay it because it's not your loan. But you want to pay it if you want to maintain and keep ownership of the real estate. So it's sort of like having the best of both worlds, right? You don't have any of the angst associated with your ability to pay and how it affects your credit and affects your other opportunities to get loans for other things. So you could just let it go into foreclosure. You could live there for a while and make payments and then let it go into foreclosure, right? You have options. At the same token, right, you can just keep making the payments. You could have 10 bankruptcies and still just keep making these payments. And as long as you keep making the payments, right, the mortgage company's probably going to be happy enough with that, even if they could get a better, a higher interest rate if you did refi. But more importantly, federal law says they can't do anything about it, which is different than if I go and sell my property or give my property to another person, generally speaking, just some stranger. The due on sale or due on transfer provisions in these mortgage agreements or deed of trust agreements, they say I have to pay that mortgage off. The note accelerates, right? The entire amount that was borrowed plus all of its interest or whatever is due. And so the Garn-St Germain Act says, well, no. Not if someone has died and another person's inherited the property. Well, that's different. That's not the same thing as someone giving away or selling their property in order to allow the next person to get the same interest rate and have the same loan terms. No, they've said, well, no, if you're inheriting a piece of property, that's not an issue. You can just keep making the payments. And as long as you keep making the payments and don't give them another basis for default, like not making payments or, burning the place down or doing something that violates the other terms of the deed of trust or of the mortgage documents, then you're free to go. The other thing that's really valuable about the Garn-St Germain Act is the other exceptions that allow you to give the property to certain people. So, for example, if you have if you own a piece of property, right, your spouse dies and you're widowed and you've just got this piece of property, and for one reason or another you decide you want to add your new spouse to the deed, or you want to add your children to the deed, or when I say that, what I mean is you want to create a deed that conveys the property to yourself and perhaps adds a spouse or perhaps adds another child. And by that deed, you're conveying that property to not just yourself, but yourself and a spouse, or yourself and a child, or yourself and a spouse and a child. And sometimes people do that for estate planning reasons. Sometimes they're trying to qualify for Medicaid. Sometimes they're just doing it to avoid probate. Sometimes they're doing it as an abundance of caution because they don't trust themselves to not get scammed, and they want another owner so that it takes two of them to sell their property. There's a few reasons why people might want to add spouse or children, right? In North Carolina, we have special protections in place when spouses own property together as a marital unit. It's called tenancy by the entirety. Not every state has that. But in North Carolina, we not only have that, but we have special creditor protections in place for people who own their property that way. So like if I go and run up a credit card bill, they wouldn't necessarily be able to sue and force the sale of that home if I own it with my spouse in this special kind of ownership. So there's some special protections in place. So sometimes if someone owns a piece of property and then they get married afterwards, right, they may want to add their spouse to the title of their home by conveying a deed. Well, that's not going to, if there's a mortgage on that property, that mortgage is going to be unaffected by that because the transfer is, while it would normally cause the note to accelerate and the due on sale provisions in the contract or in the agreement would go into effect, the federal law says even though that might be in the agreement, it doesn't matter if it's in the agreement, but it might be, even though it's in the agreement, a transfer that adds your spouse or adds your child is not going to trigger those due on sale provisions, so you don't have to worry about it. Now, if you go and you change the title to your home, you certainly want to tell your insurance agent, right? Because if the ownership is different than who's got the policy, you want to make sure that that's correctly reflected in your insurance policy, and that everyone who has an interest in this property has their own policy or is part of a policy. The other estate planning objective that really is helpful because of Garn-St Germain is trust. So a lot of people will transfer, at least in North Carolina, they'll transfer their real estate into a trust so that when they die, their real estate doesn't get hung up in this probate process, right? So when people die, they have personal property, they have real estate, they have all these different things. And some of those things go through a process that involves dealing with the court system. It's the probate process. And it involves dealing with the court system. And so when you have to deal with the court system, there's bureaucrats, there's filing fees, there's delay, there's all kinds of things about that process that people don't care for, right? It's like dealing with most any government agency. So when you're dealing with that process, right, with your property, sometimes you might proactively go to a lawyer or do your own research and say, well, I think I would be better off if I take this real estate and move it out of my personal name and move it into the name of a trust. And the reason for doing that would be, there could be a litany of reasons why you might do that. But one of the benefits of that is if it's not in your name when you die, then then it may not get hung up in that probate process, right? You might be able to deal with it more quickly. If the objective is to sell it, having it in a trust might allow you to sell it more quickly. If the objective is to have a lot of control over how it's used and what it's used for, not used for, and when it can be released to the beneficiaries and things like that, a trust is also a good tool for that. And so you don't have to refinance your home if you're trying to do that kind of planning. If you're trying to transfer your home from yourself to yourself as a trustee of this trust that you've created for estate planning purposes, the Garn-St Germain Act says that doesn't count. That's not something that's going to cause your note to be accelerated and cause your entire mortgage to be due. You can just keep making the payments like you have, and that's not the type of transfer that they care about, which is different than certain other types of transfers. The other example that comes to mind is LLCs. A lot of times people will have rental properties, and they'll want to take those rental properties and move them into a company so that if someone dies on the property or there's some major catastrophe on the property that exceeds the bound of their insurance, they don't have all of their personal assets exposed to that risk. And by having an LLC, a lot of times that creates a sort of a container around the potential liability, and it's sort of limited to what's in the company. And so sometimes people will want to take their real estate, especially their investment properties, and move it into a company. That is actually not an exception under the Garn-St Germain Act. So technically, the mortgage company could immediately, start foreclosure proceedings because you violated the agreement, meaning you've transferred this property and the whole mortgage is now due. And if you don't immediately pay that or get a new loan to pay it, that could be a problem. But what we usually would do with clients is we would say, well, get in touch with your lender and get your lender's permission. And if your lender says it's okay to transfer it into an LLC, well, that's okay, right? That now you're not going to be violating, some provision that it's going to cause your house to get foreclosed on or cause you to have to go get a new loan at a higher interest rate. An LLC would trigger, the due on sale provisions unless you got permission ahead of time. But a transfer to your trust shouldn't, in most cases. So it's a good idea to do it as part of your estate planning, if a trust is a component of it. And in fact, having real estate avoid the application of the probate system in general can cause things to be able to happen to deal with your final affairs a lot more quickly. And I think that's a huge benefit. The Garn-St Germain Act, generally speaking, has a number of exceptions, but really the ones where you're transferring it to close family, the ones where you're transferring it to a trust, and then the ones where people are inheriting it after you die are really the key exceptions that I think most estate planning and probate attorneys are glad still exist, because it would create a lot of aggravation, I think, for families in general. And certainly for people trying to avoid, the bureaucracy of, the state court system. So hopefully that's been helpful. If you have any questions, I hope you'll reach out. I regularly do this as part of my planning. We consider the application of the Garn-St Germain Act when we're doing Medicaid planning. We're trying to do specialized deeds that allow people to avoid the use of that property and counting towards their eligibility or towards the recovery against their assets after they die if they get Medicaid to pay for their nursing home care. We often will consider that if people are trying to give away a portion of their property to someone and there's still a mortgage on it, or if you have real estate investors who are trying to give money to a company or trying to give real estate to a company. There's a lot of situations where we need to look at the federal law and say, well, how does that affect what we're trying to do at the state level? So hopefully that's been helpful, and if you have any questions, I hope you'll reach out. Thanks again for joining me.